U.S. District Judge Cummings has extended court oversight on ICE until February 2026. This oversight is from a 2022 settlement reached in Castanon-Nava v. Department of Homeland Security, requiring ICE to follow strict procedures for warrantless arrest. Judge Cummings specifically called out ICE officers carrying blank administrative warrants and only filling them out after detaining an individual as a tactic explicitly designed to circumvent the law. Agents are required to document in real time the specific facts supporting any claim that a person is likely to escape before a warrant can be obtained, which is the statutory standard for such arrest. Judge Cummings even warned that officers who disregard the court order would expose themselves to possible sanctions or even arrests. Now, to be clear, ICE has already violated the law, 8 U.S.C. Section 1357A2 in the settlement, and repeatedly done so. And there probably should be sanctions and criminal referrals. However, any enforcement would require the consent of federal agencies. Any sanction would be collected by the U.S. Attorney's Office, and any arrest would be made by the U.S. Marshals Service. Now, former House Speaker Nancy Pelosi has suggested that local police could arrest federal agents under state law. Now, a state cannot unduly interfere with the ability of a federal agent to enforce federal law. The Supremacy Clause, which is Article 6, Clause 2 of the Constitution, states that federal law overrides conflicting state law. Henry Neagle, 1890, established the Supremacy Clause immunity, saying that a state or local officer cannot arrest a federal officer for actions taken in the course of official duties if those actions were authorized or reasonably believed to be authorized under federal law and necessary to perform federal functions. If a state officer arrests a federal agent acting within the federal authority, the feds would almost certainly immediately remove that case to federal court under 28 U.S.C. 114, which is the federal officer's removal statute. Then the federal prosecutor would immediately seek a motion for dismissal based on immunity. If a state wants to arrest an ICE agent, the conduct would have to go beyond their legal authority and violate state law. So in theory, if the judge in Chicago determines that an ICE agent violated the settlement, thereby establishing the agent went beyond their legal authority, and that same ICE agent violated state law, in theory, a state law enforcement officer could arrest them. Ideally, let's just all follow the law. Seems like a low bar. Here we are.